Hello to Martha. And we're going to talk about joint and several contracts. It's an interesting concept because at one time, in order for there to be anything in binding in a contract, it would have to be privity of contract, meaning if I contract with Jane and Jane and I contract, the only people that could sue over that contract for a breach would be me or Jane. There couldn't be a third party really having involvement because the law only would look to rights between those that were what's called in privity, that were part of the basis of the bargain. That's changed. That's changed a lot. And the book does a nice job talking about the different kinds of third-party beneficiaries. The one thing I want to distinguish about this concept more than the book does is the focus on incidental beneficiaries as opposed to intended beneficiaries. Many times there are people that are contract for certain things, and I'm going to get a benefit from it, even though I'm not one of the contracting parties, incidentally. The thing I think of is Palmer, Mass. is not too far from where I live here, and there was talk at one time the casino was going to come in. Let's assume there was a contract between MGM and a certain landowner in Palmer that a casino was going to come and it was going to be great. Well, I'm not a party to that contract. I don't own the land that's being sold to MGM, and MGM is not something I have any kind of affiliation with. But what if I owned a hotel in the town of Palmer and I thought, man, the overflow guests that are going to come to the casino are going to benefit my business greatly? Or what if I had real estate just outside the casino and I could develop it into something that's ancillary to its use? My real estate value is going to go way up, maybe way down too, but it might go way up depending on the related incidental benefit. The other example I give, students are, as time goes on, they're getting less and less aware of who these people are, but I say things like Bruce Springsteen is coming for 3 nights to the DCU Center in Worcester. I own a restaurant right outside of the DCU Center, say, for example, and I serve alcohol, beer, and food and all kinds of things like that. I know during those 3 nights that Bruce Springsteen is going to come to town, my place is going to make a fortune. Well, what if Bruce Springsteen breaches that contract with the DCU Center? Can I sue? I'm going to suffer some severe financial loss. I may have actually bought a certain amount of food stuffs and meats and things in anticipation of it that I'll lose money on because it'll spoil or it won't be kept fresh anymore and have to go to the freezer and then you sell it at a different standard, I guess. Yeah, I'm going to lose money. What if I owned a hotel right in Worcester and I had all this expectation? I put on more staff and all these things happen. Clearly I had an expectation, but I'm not part of the contracting party. I'm just an incidental beneficiary. And many of them you hear about complain and get very upset because they've lost economic expectation, but you can't sue over that because you're not an expected beneficiary. You're incidental. Who's an expected beneficiary? Things like life insurance. I took out life insurance, say, with Liberty Mutual. It's on my life, but the beneficiary is my son, say, for example. I put my beneficiary as one of my kids. Just one. I don't know why I felt guilty for a minute. I didn't name the other kids, but I put it just on my son. So my son's not a contracting party with Liberty Mutual. I am. So if I die, and my son finds that I have this life insurance with Liberty Mutual, and he's the beneficiary, can he sue Liberty Mutual if they somehow fail to fulfill their obligation and pay him the $100,000 life insurance policy? Absolutely. But he's not in privity of contract. Why? The law decided to change in this area, or the people that create law, legislators and politicians and policymakers, many, many years ago said sometimes privity of contract shouldn't be required if it's inherently designed to benefit that third party. Got to be cautious. There's a case problem in the back. I think some of you already might have done it. I don't want to allude to giving it away, but somebody argues that they were a intended third party beneficiary, but was it that direct, or was it really an incidental right or a vision of an incidental right that they thought they should have rights to be able to sue over the contract? And there's a distinction. Otherwise, it wouldn't have been a lawsuit that went to the appeals court. So there was a bit of a debate about it. But in order to be a donee beneficiary or an anticipated third-party beneficiary, you almost have to be named in the contract in order to receive benefits under them. Now, what do we care about this stuff? That's the little introduction part. The other things that we're talking about are what we can do in terms of assignment of rights and duties and or delegation of duties in a novation. Might as well start with novation. I always love the term because it sounded so serious, and I've done a few novations before. And my father was a plumber, and I was a lawyer. I was living at home for a while there when I first became a lawyer. And my father said, "Oh, today I changed the tire of a hot water system to a gas from electric, and I worked so hard." He goes, "So what'd you do today?" And I always remember trying to look at him like I was so sophisticated. I did innovation, as if it's almost something like a religious thing. And all innovation is there's three parties. I'm originally contracting with Jane to have my house painted. And in the middle of the executory period, she hasn't painted my house yet. I haven't paid her yet. And I decided somewhere along the thought process, even though we have a binding contract, the contract's legally valid. Both have made agreements. We're competent. We have a meeting of the minds. And for some of you that think you have to have it in writing, we put it in writing just to make you feel comfortable. That kind of contract does not have to be in writing, by the way. It's a service contract. Contracts like those don't have to be in writing. Should they be? Sure. So there's no debate about what was actually agreed upon. And it's easier to prove in court. But it didn't have to be in writing. So now we have two contracting parties. Me, Jim Corman, going to have my house painted by Jane's Painting Service. It's for $4,000, 2 coats of paint, something like that. And I decide, as she says, I'll probably be there in late July. All of a sudden I think about it and I said, you know what, I think I want to put siding on my house with a thin layer of insulation. I think it's going to be more cost effective. I don't have to have it painted every few years. Vinyl siding's come a long way. I really changed my mind. Can I just call Jane and say, hey, things are off? Legally, no. She could sue me and say, I can't replace that work because I set aside that time and I'm going to suffer some damages. I'm going to suffer financial loss if we don't go forward, Jim. I'm going to have to sue you. We had a binding contract. She can't force me to go forward with the contract, but she could seek damages. And so she might be able to prove she couldn't find a substituted job to fill in that gap. But what if she did? Then there'd be no damages and everyone would be in status quo ante, and therefore her lawsuit would fail. You have to have damages in order to sue, even under contract. Just because someone breached a contract, you don't win the case unless there's damages. And I think that's hopefully covered in a later chapter. If not, I'm going to review it again. But in innovation, say all of a sudden I decide I want out, but I realize Jane's not going to let me out of the contract without potentially suing me. And it's probably true. She couldn't find a fill-in for that time she contracted to work here. And it's going to cost her some damages and she'll have a successful lawsuit against me. Maybe we can do innovation. What we might do there is I might contact for my son, for example. He has a similar square foot house as me. And I know his house needs paint. And I'll say to Jane, it's really not far away. There's not going to be any, it's actually closer to Jane's painting company. What if I said to Jane, I said, hey, how about an innovation? And all I'm saying to her is, how about you substitute me for my son? My son will step into my shoes, for lack of a better way of saying it by analogy. In that way, when I get removed from all contractual obligations, there's no right to sue me for damages anymore, no right to sue me for money, and I fictionally sort of rise out of my shoes and become completely absolved of any responsibility of the contract, and my son steps into my shoes and he becomes fully responsible to pay Jane and Jane to perform the services for my son. All three parties have to agree to the innovation. Why? Maybe Jane doesn't want to work with my son. Maybe she's uncomfortable. She wanted to paint this house. And I have to agree, and so does my son. All of a sudden, my son can't wake up and say, hey, what's this painting crew here? I don't want anything to do with it. I don't want to be financially or legally responsible for a contract that I didn't agree to. All three parties have to agree for innovation. It's a nice term. It doesn't come up a lot. It usually comes up a lot is assignment, which is similar, but it's different. Innovation, what did it do again? It let the delegating action called out, but let one party completely remove themselves and substitute a new one. Most people don't do innovations. Most folks in business or business entities do what we call assignments. When you hear the term assignment, think of rights. So say I did a divorce for somebody and they owe me $5,000. Can I assign the right to receive that $5,000 to some third party? Sure. Companies do that all the time. Credit card companies, if those of you have ever been in credit card trouble, I know I was when I was younger. I fall a little bit behind my bill, and initially it's, the Visa card company calling me, and you don't answer the phone. And then eventually some other company calling you. It's, Acme Credit Collection. Who are they? They may have actually been assigned the right to collect that debt. They bought the debt from Visa for probably a discounted price, and they have the right to collect it now because they've been assigned the right. Usually rights relate to monetary rights, but you can sell your right to a copyright. You can sell your rights to a patent. You can sell your rights to any kind of legal standard that you might have in your favor. So it's a very powerful tool in business. It happens all the time. Usually, though, it relates to some kind of monetary interest. Now, what's interesting about that is usually the assignor, that's me giving up the right to collect the money to the assignee. say Fred's Debt Collection Services. I don't want to chase down my former client for that divorce money. I make certain warranties to the assignee that and I think it's well written in your book, and let me refer to it. You should give a notice of assignment. So I used to tell my former client, Judy, who I did her divorce for, Judy, I'm not going to be collecting that bill. I've assigned that right to Tom's Debt Collection Services. So when they contact you, you've gotten notice of the assignment. If my contract was in writing, the notice of assignment should be in writing. If it was just oral is fine too, but the notice of assignment that has been assigned to somebody else should be done in the same form as the underlying contract. And that's what the law usually requires. Actually, where assignment of right comes up all the time is in mortgages. You take out a mortgage with a bank, you're usually not really taking out a mortgage, you're taking out a loan. We call it taking out a mortgage, but you're borrowing money from the bank. You're promising to pay them back with some interest over time. The mortgage is the security interest in the home you bought. In case you don't pay, they basically get to foreclose on your home, and then they sell it, and that's how they get their money back. It's a secure transaction. It's the way they protect their interest. What's interesting about that, a lot of banks initiate these loans. And so say you went to, I don't know if they'd even do this, but Gardner Savings Banks initiates your loan. You get a 4% loan on your $200,000 home. You put down, I don't know what 20% is anymore. $40,000 on the home, or is it 20,000? 20,000 would be 10%. So yeah, you put 20% down. You don't have to, but to avoid something called PMI. This is not a real estate class, but you put down your 40 grand. You buy this $200,000. You get a $160,000 mortgage, and you're going to pay some interest back to Gardner Savings Bank. But usually Gardner puts right in that mortgage agreement and that loan agreement that they might have a right to assign it. They might assign your loan and sell it to Bank of America or Fleet Bank. I don't think is around anymore, but they could sell it to some other bank. Does that change your rights and obligations, the non-assigning party? You're the homeowner, you're the mortgagor. It changes nothing in terms of the dollar amount you have to pay, the time you have to pay, and the interest you have to pay stay exactly the same. The only thing that changes is the party that's been assigned the rights is the one that now gets it. And there's a lot of fraud in this area. So that's why if somebody contacts you and says, hey, I've been assigned the right to collect this debt or that debt, and you pay them, if they were not assigned that right, you still have to pay the original, quote unquote, original assigner because they never assigned that right. You were just wrong to believe that somebody duped you into thinking you had that right. And people can look up mortgages in the registry of deeds and create a little scheme if they want to. Be very cautious. So you should be given notice, but one of the test questions is, do you legally have to give notice in order to enforce a valid claim of assignment? No, because the enforcement of the claim is notice that you have it. You just let that debtor, the debtor has the right to confirm the truth of that, but the lack of notice doesn't mean the legal transfer of rights did not occur. Meaning this, if I gave up that $5,000 to collect that debt to somebody else, that's now valid. They own that right. It doesn't mean it's going to create any difference in the right simply by them failing to notice until later on. Notice is not an element of the validity of me to transfer the right. And again, rights are usually about obligations to receive money. What about delegation of duties? I'm a painter. You hire me to paint your house. Could I delegate and both assign and delegate the duties to another painter? Believe it or not, I can, unless the contract has a non-delegation clause. And businesses do this quite often. So say I get really, really busy as a painter and I'm getting all this contract work. I don't want to turn it away. Could I sub out those jobs? That's what subcontracting is basically assignment of rights and duties. Sometimes I just delegate the duty and I retain the right. So I'll just hire a subcontractor and say I got $4,000 to paint the house. I might hire somebody else if I can find them for $3,000, not an ovation, because I'm still staying legally bound to make sure the painting is done in a workmanlike manner in the time frame that the contract requires, if it has a time frame, reasonable period of time, if there's no specific time frame. And so the homeowner is expecting me to come and paint with my crew, but another crew shows up. Am I liable for that? Can they say, oh, no, we hired Corman? No, they can't unless they had in their contract a non-delegable clause, and many don't. So sometimes they're surprised. Am I liable for anything? Well, if the paint job doesn't come out to the standard performance of a professional painter, then they can sue me because I still remain what? Liable to make sure the duties were performed in a standard that's required under the contract. It's kind of common sense in most parts, but sometimes people are surprised. You hire plumber A and some other plumber shows up at your job. As long as they do a good job, you don't really have a right to complain unless you put in a non-delegation clause. The good news for most of us, and I think society expects that certain jobs, especially service jobs, performing certain duties, relates to a certain bond of trust, reputation, integrity, confidence. And those kinds of contracts are not delegable. And I'm not trying to brag or anything about being an attorney, but usually when you hire an attorney, you hire them because of reputation, their skill, their experience, and all those things. So if you hired me to do your divorce, you wouldn't expect some other attorney to show up at the day of trial. If you're going to go all the way through trial, you expect me to do your criminal jury trial. You hire me because you heard I do well in those kinds of cases, or I do reasonably well, and my fees reasonably well. You don't expect somebody else to show up, and you would have every right to object. So usually things related to professional services, things like psychiatry, surgery. You hire a certain, I'm having back surgery, say, for example, it's pretty serious. I hire I don't know, some doctor that's well known in the orthopedic surgery field. I expect that doctor to actually perform it, and I shouldn't have to worry about delegation. Those you can't delegate. I think they gave some other examples in here about what you can't delegate for certain kinds of duties. Process and delegation. I have to take off my glasses to read now. I know it sounds bizarre. Yeah, it says only when the performance is standardized may one delegate. Things like painting, carpentry, landscaping, those are kind of standardized, called workmanlike standard, and it doesn't say that in the book. But the other one is here. It talks about certain things where there's a personal element. If there's a personal element, like a band that has a reputation for certain kinds of music, they can't delegate that. They give an example of a divorce attorney, ironically, here. In those that have things to do with trust and confidence, and I don't always know what they are, but think about it. You hire, I don't even know who's big in music anymore, but you hire Justin Bieber to come and sing at your wedding. You don't expect Cher to show up. I don't even know if you know who these people are. I think I just combined two different people there anyways, but you get my drift. If you hire a certain person based upon the reputation, skill, and qualities that you want, you don't expect them to delegate, and the law would not require you to comply with that delegation. Now, what's interesting here is, what if you hired me to do your divorce and you suddenly fall in love again with your spouse? Usually it happens either on Valentine's Day weekend or around the holidays or the kids' birthdays or something. You get back together and you say, hey, good news, I get back together. I don't need you to do my divorce anymore. I say, well, that's fantastic. And they say, but I want you to do my sister's divorce. The non-delegating party, the one with the duty, can't be required to perform their services for a third party. That's actually banned. People are surprised by this, but if you read the case law, it's actually banned by the 13th Amendment to the United States Constitution, which is indentured servitude. You can't be forced to work for somebody you don't contract with. You just can't delegate. So I work for the Mount, for example. They can't say, Jim, we want you to go to Anna Maria this fall or to Quinsigamond and do your job down there. They can ask, and I can agree, but can they make me? No, the duty is not delegable unless the party that has the obligation to perform assents to it. Otherwise, it's deemed a form of indentured servitude, which is unconstitutional. So assignment of duties, again, those are the rights. Delegation of duties is about the performance of usually some kind of service contract. And sometimes you can have both just have rights. Like, I have the right to buy your car, you have the obligation to pay me money. Neither of us are doing a service, but we can both delegate and or assign basically the rights flowing back and forth between the two different parties. And again, different than a novation. A novation is when somebody is switching out for somebody else with all the legal rights and obligations. And remember, the assigning party, if it's just assignment as opposed to novation, has all the same legal ramifications against them if they should fail to perform what they're legally obligated to do because the assigning party didn't do what they were supposed to do. And again, the form of assignment should mirror the nature of the assignment that is done in the underlying contract. And again, if you don't want, you hire a carpenter and you're really hoping they do the job, you don't expect a bunch of subcontractors to come in, you can put in the contract that these services are not delegable. And I actually worked for a very large law firm. I was a rookie attorney. I was pretty much right out of law school, and I got lucky to land this job in Worcester. And they hired this attorney who was very gregarious and had a great reputation as being very effective. And I can always remember showing up sometimes to court the day of trial. We didn't really, back then, they used to really throw me into the ocean and expect me to swim. But you can imagine the client's facial expression when sometimes a few days before trial, hopefully, there wasn't a day of trial, I'd be contacting them, come in the office, we got to prep for trial, we got to get ready. And they'd be like, well, who the hell are you? I said, well, I work for so-and-so. Because, yeah, but I hired so-and-so. And I said, well, you hired so-and-so. And I always felt bad about this. Because remember, that's non-delegable. You hire an attorney for trust and confidence. Guess what he put right in his contract? You hired him and any of his associates he should so delegate to perform the services. So all they could complain about is if I committed malpractice, they could sue him and me. They could sue both of us for malpractice. But he did have the power to delegate because he threw it right in his contract. How about on the other end? You're the one receiving the services. What should you put in your contract? If you got this painter, you think he or she is fantastic, or you got this, I don't know, landscaper, you think he or she and their specific immediate team is great, you could put in there that the services are not delegable to some third party. And that way, you get the services done by the person that you really want to do the job. Form of the assignment, effect of the assignment. Warranties of the assignment. All the warranties are promise that certain things exist. And if they don't, and you get harmed as a result of the thing not existing, you get a right to sue. And the one is that the assignee is the owner of the right. Imagine somebody contacting me and says, hey, Jim, Tommy owes me $5,000. I'm really broke right now. I'll sell you that right to collect the $5,000 for $2,000 right now because I'm really in a need for money. Could that be a valid contract? Sure, we're competent. What are we exchanging? He's exchanging me a right, and I'm exchanging $2,000. So I'm hoping to claim the $5,000. Now, what if I go and see the guy that owes him? I think I said Tommy owed the money. I said, Tommy, I just bought this right from John, a $5,000 note that you owe. And what if John comes back and says, or Tommy comes back and says, I don't owe any money to John. What are you talking about? And basically, Tommy committed fraud. Well, John wouldn't owe me the money. What could I do? I could basically sue for breach of warranty of an assigner. The assigner warranted they own that legal right. They did not. It was fictional. It's not always about crime. Sometimes they can actually think they own the right because they bought it first from somebody else, and it might be trickling down through several different assignees. And when it finally gets to me, it turns out to be an invalid claim. If it's an invalid claim, I can sue the assigner because they're basically warranting it's a valid claim. It exists in law. Those don't come up that much, but they might come up enough. The next one is that the right is valid in subsisting at the time of the assignment is made. That's pretty much, I think, synonymous with the other one. They go hand in hand. One is that there is a real right in that they have the power to assign it. They both are related. And this is my favorite. There are no defenses available to the debtor that have not been disclosed. If they're disclosed, that's fine. So say somebody owed me $5,000 for a trial I did for him. I really bombed it. I did a terrible job. But I did the work. I went to jury trial. I put everything together. And now this person owes me $5,000 and I assign the right. Now, is there a potential defense to collecting that right? Yeah, they could say I committed malpractice and therefore they shouldn't have to pay the amount of money. Now, could I still sell that right validly and not breach this warranty? Yeah, but what would I have to do? I'd have to disclose, look, they owe me $5,000, but they could raise the potential defense to collecting this right because I arguably committed malpractice. And this comes up a lot in assignment of debts. Sometimes people sell debts a lot, and sometimes people come back and say, I don't know that debt. They didn't perform work on the other end, or I don't know that debt because the goods they sold me were defective, or the food they sold me on the delivery service. We have some called Swan coming here. I've never heard of it before, but Swan? I think it's Swan. They deliver their own food products from some kind of warehouse, and we don't pay them when they come here. They send us a bill and we pay them later. Or if we didn't pay, Swan might sue us directly, but could Swan simply sell or assign that right to collect that? Sure, they could. And then what did we say? Well, the reason why we didn't pay them was they gave us a bunch of melted ice cream and rancid meat. We shouldn't have to pay for it all. It was worthless. And so if they knew that we raised that issue, they would have to tell that to any assigner or be a breach of the warranty of no known defenses or claims of invalidity in some fashion. Kind of common sense. Joint and several versus joint contracts, several contracts, and joint and several contracts. A little tongue-tied on these sometimes. Joint contracts means we both agree to pay the whole. And so that means we both agree to pay the $10,000. So if they're going to sue us, they can get $5,000 from each of us. Several means it's an individual contract. Several means severed from the other individuals involved, so they have to sue us individually. Most contracts you're going to worry about, and what you do want this as the recipient of the right. So if you were dealing with me and 5 other people and there was a contract to pay some money to you of 100 grand, you'd want the contract to say the payment by Jim, Martha here, the dog, well, not a real person, but Martha, my friend, Jane, Steve, and Bob. You say we joint and severally agree to pay. And why do you want that? That means you can sue all of us. You can sue select members of our group. And why would you might that have that power? When you look at the lawsuit, you may say, I'm suing for 100 grand. Jim's got some money. I know Jane's, basically, worthless. Why would I even bother putting her in a lawsuit? In each one of us, I know it sounds a little bit bizarre, each one of us on a joint and several contract is obligated to pay the $100,000. That doesn't mean the other party gets $500,000. It just means that all of us have the independent obligation to make the other party whole. And it's the way most contracts are written. Most contracts are joint and several because if you're the other party, you're going to say, yeah, I'll agree with 100. You guys owe me 100 grand, but I want to joint and several. I don't want to have all of you contribute an equal amount because Corman pays his 20 grand. I'm not going to get the other 80 grand because the others might become deadbeats. I want as many options to collect the whole as possible. And this kind of relates to criminal law in a way. I do a lot of criminal law work. And a lot of times there's restitution issues involved with multiple parties. And the court always orders, say come out $5,000 restitution. And there's 3 defendants. They always say, well, make it easy. It's $6,000 restitution. There's 3 defendants. The judge always says joint and several restitution to the victim. And of course, this happens to me many times in my practice. My client will call me and goes, hey, I paid my 2 grand, Corman. I'm all done. And probation was only until I paid the restitution. I'm good. Thanks for your representation. And I'll say, well, wait a minute. Did the other 4 grand get paid? And he goes, I don't know. It's not my problem. He goes, well, it is your problem because you jointly and severally promised to pay. And now the probation department can violate your probation because you had the legal obligation to make that victim whole independently of the other 2. So whenever I do it, I always try to get the judge to just give several. So I want several liability to pay. So basically it's equally broken out. Joint is you'd have to sue all of us and then we'd all have to contribute, very similar limitation. But joint and several make sure that the victim gets made whole. And I actually had a probation thing like that where my client paid his equitable share, but he was still liable for the whole balance. And he was the only one working. And where was he working? United States Marine Corps. I was getting case basically dismissed upon restitution. This was big money, though. This was like $70,000. And I think there was, well, just make it simple. It was like 7 defendants. So my client had to come up with what? Don't say 10 grand. He had to come up with 70 grand if the other parties failed to perform, or they'd all be in violation. And who's the one that's ultimately going to have their wages attached? The one that's got some money coming in. Using the Marines, he had a paycheck coming in. At least the other ones were not doing so great. I convinced the judge to basically revisit the sentencing or the terms of resolution of the case and turn it into simply a several obligation. So my client was done and could be discharged from probation and continue on in his Marine Corps career. Things worked out well in the end. I don't know if it worked out well for the victim, but it worked out well for the defendant because I try to argue an equitable claim and why should he have to pay the whole. But on the other side, they'd argue, wait, I don't care which of the defendants or all of them, whether they pay me. I just want to, I'm the victim of a crime. I want to be paid whole. So you get why most contracts in most criminal cases require joint and several. Not a fun chapter, kind of boring to be quite honest with you, but it's important. Third-party contracts come up a lot. Donee beneficiaries, let them on creditors and rights like that. And I think the book is somewhat straightforward. So hopefully I went a lot longer than I probably should have on this thing, but I'm exhausted. I just got back from Boston. So, have a good couple of days. I probably won't get anything on tomorrow, but I will Friday. And those of you that are concerned about homework assignments, don't take a quiz until you have feedback on the homework related to it. The quiz will stay up until it's done. I apologize if I fall a little bit behind, but it's just that weird little point in the semester where I didn't think I'd have to go to Boston every day for a week, but I do. And be well. And don't be afraid to ask questions or raise concerns. And if I haven't gotten back to you, it's just because I'm a little busy, but I will very soon. Promise.